For those of you who listened to the last meeting that I was involved in, you'll just have to suffer with me. You may hear some of the stories twice. My wife's been hearing them over and over for the last few years. Before we were married, before many of you were born. You're also liable to hear not only some of the stories over, but some of the ideas and concepts. Before I start, just a word. I practice law in New York City, and I represent all kinds of clients in the entertainment industry. Can you all hear me? The acoustics here are marvelous. One of the things I do is teach out at Hofstra Law School, and they have a tremendous... I was supposed to have 28 students. 85 signed up for the course. It was supposed to be a seminar. It isn't. I also teach at the new school for social research in New York City. I started out teaching at York University in Toronto. About 5 years ago, I did a seminar for some of the top theater people in Canada, and someone at York liked the idea, so they offered me the opportunity to fly up to Canada every week for 13 weeks. This was 4 years ago. I was responsible for the snow and the sleet and the inclement weather they had that winter because every time I arrived, it was impossible. I decided, I took the job because I didn't like to fly very well, and I knew if I had to get on a plane and teach, and I had to do it once a week for 13 weeks, I'd learn to like to fly. It's become almost tolerable. In fact, it's more fun than you can imagine because one time they had I was also responsible for the strikes that year. They had a radar strike, a ground control strike, and an electrician strike. During one of the strikes, we flew to Buffalo and took a bus from Buffalo. It was at that particular evening that I really learned to like to fly, that bus ride from Buffalo. Now, I'm not sure what I'm supposed to talk about because the subject, law and the performing artist, is a pretty broad subject. This is what I teach, law and the performing artist, and it takes me between 30 and 40 hours. I could easily stand up here and talk to you for 10 minutes and tell you one or two stories, or I could talk to you for 30 or 40 hours. It's this 2 hours that kind of throws me. So what I'm going to do, maybe some of you will have questions, maybe even some of you will have questions I can answer. I'm going to talk for a few moments about what I do as a lawyer to help people in the performing arts, to give you some idea of what an attorney does in this industry, and when you ought to need an attorney in this industry. And after these few observations, I'll answer any questions. In fact, if you want to interrupt me anytime along the line and ask questions, I don't mind. I'm accustomed. Law and the performing arts, yeah. I started to make a comment earlier at the last session I spoke at about the concept of ownership of literary property. And I mentioned the fact that none of you here would run outside and grab a cloth and a pail of water and start polishing somebody else's automobile and shining up the hubcaps. Yet every year, about once every 6 or 7 weeks, somebody comes to me with a beautiful adaptation they've done of a novel they don't own. It happened just recently. The chap lives in Hawaii, and he got in touch with me through a client in California. The author of the novel lives in Wales, and this chap that I was going to represent did a musical adaptation of this novel. The film rights in the novel had already been sold. So he comes to me and he says, I've got to get the rights to this now that I've done the adaptation. I've spent so many months of my life working on it, and there's a producer who wants to produce it. I did, with some difficulty, get the rights for him to do an adaptation of that novel. I did, with some difficulty, also acquire the right to do a film of that successful stage production he's going to have. You see, it isn't just enough to own the rights to do it on stage. After you've got your successful successful I Am a Camera, which becomes a musical cabaret. You then want to do a musical of the musical, a musical movie of the musical stage version. So you have to have all these rights. I did with some difficulty. It would have been a hell of a lot easier had he come to me in the first place, because one of the things that you learn very early in this business has to do with bargaining power and how big a club you have. And the guy took my club away when he did all the work, and he had to have the rights, because if he hadn't done all the work and I couldn't acquire the rights, he could have spent the same amount of effort working on something he could acquire the rights to. Now, ownership. That's really what a big chunk of what I do is all about. You ask yourself, who owns what? And then you set about trying to get it. And you can borrow it, you can steal it. Some people do. I don't recommend it. I don't recommend doing an adaptation of somebody else's property. So you have to find out who owns it and acquire those rights. And in doing that, you soon learn that, and this is one of those observations that sounds so simple, I don't know, you say, well, why didn't I think of it? What's really important is knowing what's important. And that's why very often, if you're going to do any kind of negotiating, you're better off to have someone negotiate for you who knows. Example, I do all of the legal work for Stratford Shakespeare Festival in Canada. I do their dramatic work. I don't handle their corporate work. And we were trying to acquire the rights to produce a play there, and the person that owned the rights was someone down in this country. And I was dealing with an agent in New York, young woman. I almost said young lady. You can't do that anymore. A young woman. I've been accused of being a male chauvinist pig. I use the term lady and girl. So a young woman agent was representing the author. I prepared the contract and sent it to her, and I got something I've never gotten. 5 pages, single-spaced, 21 objections to my contract. I had a young man working for me at the time, and I figured 21 objections to the contract. We can spend the rest of the day talking about that. And I don't have the time to waste. I didn't want the young man working for me to waste the rest of his day arguing with the agent about 21 points. So I said, John, I'll handle this for you in a minute and a half. Watch. And I did. I picked up the phone, I dialed the agent, and I said, hi, I got your letter. You got 17 points that you asked for. The other 4, never, over my dead body. Of course, I gave her ice in the wintertime. The 17 points I gave her were absolutely meaningless. She went back to her client and said, wow, did I make a success for you? I had 21 objections and I got 17 of them. The 4 I kept were the only really important things in the contract. So in representing someone, in trying to negotiate these kinds of things, what's important is knowing what's important. Now, we're talking, I'm talking now about acquisition of rights and ownership of rights, and this has to do mostly with literary properties. A lot of what I do, I also represent artists who are performers. Now, before I talk about that, most of the work that a lawyer does for the people in the arts has to do with contract law and with copyright law. I'm sure that many of you have the mistaken impression that in order for a contract to be enforceable, it has to be in writing. Well, as a matter of fact, I just defined a contract for you. This is another thing I try to teach my classes, especially those that are not in law school. In the law school, they're supposed to know what a contract is. When I teach at the New School, though most of them are not lawyers, although some of them are, some of the lawyers don't know what a contract is. It's preferable when you're dealing in one of these areas that you have a lawyer assist you. But there are times when you're stuck and you can't get to a lawyer, or you, for one reason or another, you must have a contract. I think everybody who deals with contracts ought to know what a contract is. I think they ought to know when it has the elements that would make it a legally enforceable agreement, which is what a contract is, a legally enforceable agreement. And contracts aren't only important to the people that are affected, because we're all affected in one way or another. The contracts in this business overlap. There's a complete interdependency upon other people, but there's an interdependency as far as the contracts are involved also. Now, just very briefly, a contract needn't be in writing. In fact, it doesn't even have to be oral. In fact, you can enforce a contract. Example, you walk up to the box office and you throw $3 down, and the gal behind the booth hands you a ticket to the show. It's a contract. Nobody said a word. You didn't even shrug your shoulders. All you did was throw down the $3. If the show doesn't go on, there's an implied agreement that the show will go on, and you can sue to recover your $3 back. The thing I'm trying to illustrate is that there are certain elements of a contract. They may be oral, they may be written, or they may be implied. And the elements of a contract, which those of you who are lawyers know, is that there must be an offer and an acceptance, there must be consideration, and there must be specific terms. Now, offer and acceptance, somebody says, I'll give you $500 if you do the set for me. And the other guy says, okay, I'll do the set for $500. The consideration is the payment of the $500 for the doing of the set. But what's important to you, the things that you should know, and whether you're drafting contracts or you're not drafting contracts, whether you're negotiating them and somebody else is going to write them up for you, is that you have to have specific terms. You cannot enforce an agreement to agree in the future, and you can't enforce an agreement which says that the director is going to be permitted to direct all of the future productions upon terms that will be agreed upon, or unless you have all of the terms settled that are not vague and not uncertain. Now, the trouble with what I have to talk about, and the reason it's near impossible talking for 2 hours, is that everything I'm going to tell you has about 15 exceptions. In fact, that's what our business is all about, the exceptions, because when I say to you it has to be specific and it can't be vague, can't be undecided. Films are made all the time before the people have completed their negotiations. I handled the Happy Birthday Wanda June when it was made. Kurt Vonnegut's the client I represent. And I also represented the independent producer of that film. There was a deal memo that was drafted which contained about 1/12 of what was in the final distribution agreement. The reason this contract was enforceable was the parties acted like there was a contract. One of them parted with a lot of money and the other one took a lot of money and made a film. But for the most part, you have to have specific terms. Well, this is part of what I do. The other part of what I do has to do with copyrights. I want to just get over some of these basics so you can ask whatever questions you may have. Copyrights, the copyright law. It was mentioned earlier today that you can get copyright protection for something you create for 28 years, and then for an additional 28 years if you renew the copyright simply by sending a form and $6 together with one copy of your script to the Copyright Office. About 10 years ago, our legislatures in Washington started working on a new copyright law, because in some other parts of the world an author can get protection for 50 years plus his life. There are two copyright conventions, the Berne Convention and the Universal Copyright Convention. A lot of different countries belong to those conventions, and all the countries belonging to those conventions get this longer protection. The United States finally has gotten around to the idea that we should have that same protection for people who register with our Copyright Office. So they're thinking about changing the law, but they've been thinking about it for the last 10 years. And until each 2 years, they extend the period so that any copyrights which expire during that period are automatically extended. So any copyrights which have been expiring during the last 10 years are automatically extended until they complete either thinking about the law or forget about the law. Now, I just want to mention one or two other observations about performing artists, actors, actresses, agents, and managers. I've written some books on theater law. The first two books I wrote were on producing, and the last book I wrote is on producing. The first two one was on producing off-Broadway, one on producing on Broadway. The last one was on producing films. But the third one I wrote because I wanted to do something to explain to actors and actresses what they do when they sign a management and agency contract. I really am not terribly bothered if someone gives away their right arm or their right breast or whatever if they know what they're doing. It troubles me greatly that many people in this industry walk off having given away more than their right arm without knowing what they're doing. So I sat down and wrote what I thought was going to be an explanation of management contracts and agency contracts. That was fine, except that my publisher, editor decided that, well, hell, as long as you're doing that, why don't you just digest some of the other standard contracts? So I digested the 127-page SAG contract into about 7 pages. It gives you an idea what's there. It doesn't really serve much other useful purpose, except that I want to alert anybody who's a performing artist that if they're ever handed a contract, agency management contract, for an example, you can sign a management contract. Agency contracts are less onerous because many of the agency contracts are negotiated and approved by the performing unions, Actors Equity, AGVA, AFTRA. They negotiate the contracts and they approve of them. But with a manager can ask anything he wants. I'm not troubled so much by a manager coming in and taking 25 or 30% of what someone earns. That's understandable if you want to give him that fine. An agent's limited in most instances to 10%. What really troubles me about some of these management contracts is the kind of thing which says the manager can spend your money as he sees fit to further your career. For his own purposes, he can take a trip to the coast and reimburse himself from what you earn. I think, it's just in my head, if somebody's spending my money, they ought to ask me. The other kind of thing that troubles me in a management contract is somebody's being able to make a determination where you're going to be working on a particular night. I think if you're smart enough to be in the business and in the business performing, the manager ought to ask you, how would you like to perform in Nashville on the 24th of June? Not so. Managers can make commitments for you if the contract's so written. Not only can they make a commitment for you, but they have a power of attorney to sign the contract as well as to make the commitment. Now, many of my contracts, I got a power of attorney from 2 or 3 or 4 clients. Well, Kurt Vonnegut, I have a power of attorney for Kurt. I sign all of Kurt's contracts for him. But, I'd never dream of signing one of his contracts without asking him what he thinks about it. I might sign something we've discussed in detail. I think that the artist ought to be in a position to make the determination himself or herself. This is what a lot of what I do in the business. Now, if there are any specific questions, if not, do you have specific questions about law and the performing arts? Yes. I know some things. It's most usually, if one gets into a complicated tax problem, I strongly urge that they consult a tax consultant or an accountant. I have trouble enough being as specialized as I am in my own field. And if you have a specific question, I might be able to answer it. If you are troubled by something, and I couldn't answer it, at least sometimes when I'm representing people, I know when there is a tax problem, I know enough to tell them to get help. It's not something I do, if I can avoid it.
Well, it was just, people have said there are certain tax benefits that artists can have but don't know about, and so they can't utilize them. And that's what I was wondering.
Well, there are all kinds of tax benefits that can accrue to people, but I think so much you can't answer a question like that in the abstract. I think it depends on whether your income's $250,000 or $15,000. When I've got a client whose potential income is in huge quantities, and I'm negotiating a publishing contract for him, I may wish to limit how much they pay out to him each year, no matter how much he earns. I don't like to tell the publishing company to keep my clients' money and let them earn the interest on it, but it might be useful if I know he's got other income from films. And so these kind of questions, I mean, there are certain ideas you can talk about, but you can't answer any particular question like that abstractly without knowing all of the details. Yes? I can't hear you. Could I, textbooks, you mean about, well, you mean what I teach? Oh. Actually, what I teach has to do with the whole area of producing. If you're interested in producing, specifically producing theater, the only textbooks I could recommend on that are the textbooks I wrote. I don't like to recommend. You know, when I teach at the new school, I've never made one of my books required reading, and not the last time, but the time before, at the end of the class, we usually sit around and we talk for about an hour. That's the next to the last class. The last class we all drink at my house. The next to the last class, we were sitting around talking. I asked the kids, the students, what they thought might improve the class, and one attractive young lady stood up and said, I think you should make your books required rather than recommended. So if you're interested in theatrical production, the books I've written on that would be useful. The one from option to opening for off-Broadway, and producing on Broadway is a Broadway source. What I do and what takes so much time is there's a very detailed. Who owns what? You got a play that's going to be produced based on a novel. One guy owns the basic rights in the novel. He sold off the film rights to someone else. The book was published, so he got a publisher. And now a producer comes along and he wants to acquire the rights and do an adaptation for the stage. Well, first he gets the rights from the owner of the basic work, then he gets the rights from the people who own the film, because you want to do a film if it's successful. He can't get the publishing rights, so forget it. The publisher isn't going to part with him, and he hires a book writer, composer, and lyricist. Well, if he's got the right rights, if he's got the film rights and everything else, he'll get a good book writer, publisher, composer, and lyricist. If he doesn't do well in acquiring those rights, he won't get good people to do the adaptation, because they're the ones who end up with those specific rights. After you get the book writer, composer, and lyricist, you go out and you hire a director. And then from the director, you get a star. Now, who ends up with what? How do they share the proceeds? Oh, you forgot the producer. How do you share the proceeds? Well, that's what I teach. That's why I said that's pretty lengthy stuff, and that's why that's what lawyers in this business do, largely. Also, the employment contracts, where people are employed in different ways in the business. There was another question. Meet them at Sardi's and drink with them. What do I do for performing artists? It depends upon, you're talking about actors and actresses. Yeah. I handle their contracts, and some of them I handle their personal business as well. For an example, if one or two instances I handled the immigration proceedings to get them into this country. You handle the management contract, the agency contract, their employment contract when they're employed by a producer. And you handle their wills. When they purchase a house, you take care of the house. But strictly in the industry, it's mostly contract work, largely contract work. I beg your pardon? I think I think everybody needs a lawyer, whether they're a performing artist or not. You know, so many people think in terms of what lawyers do as being the kind of thing that is, when I get in trouble, I'll call you. Well, most of what I do is for people who are not in trouble. Most of what I do is putting things together. What I do is negotiating. And if you're a successful, or if you have any kind of success at all as a performer, you should have an attorney. Right away, you're engaged by an agent. You should have an attorney examine your agency contract. I think it's important. Yes, there was another question. Well, you're talking again about a performer or a creative person? Both. Oh, both. All right. One of my clients for a while was Duke Ellington before he died. Duke needed advice on his film work and theater work. He was going to be doing a film before he died. One of my clients had acquired the rights to do a musical stage version of The Hustler. Do you remember Minnesota Fats? Duke was going to do the music. Well, that contract I had to handle for him. I had to negotiate it for him. It's largely negotiations and largely contract work, depending upon what the client does. What kind of trouble? Oh, forgive me. Yes, I started out to tell you about trouble. Someone engaged Kurt to do a concert in the park, Ron Delsener, who's a producer of musical contracts in Central Park. And of course, in every contract that the Duke, well, let me tell you now, one of the things, we don't fight about money, we fight about billing credits. Whose name is bigger and where it goes? That's what you hassle about all the time. It's the nature of this business is, and it is a business. It's a very personal business, and it's an ego business. And part of what we hassle about is the size of the name. Well, naturally, Duke Ellington's contract had the Duke's name largest. Well, Ron Delsener wanted to get a young rock group, and in order to get the young rock group, he did say in the contract that they would have top billing credit. Well, you learn after you've been in the business a little while, you can't have top billing credit for more than one person. And in a moment, I'll tell you about the granting of exclusive rights. So he knew that the young gang might cause trouble and the Duke wouldn't cause any trouble. Well, I was livid that he put this young gang's name above Duke Ellington's. You just don't do that. It's just not nice. And I had a perfect lawsuit. But I talked to the Duke and his manager, and we decided it's one of those perfect lawsuits we don't want to enforce because it just wouldn't be worth it to him. I mean, he's so big, he was so big, his stature wasn't hurt that much. But that's what I mentioned before about contracts all being interdependent. Well, it depends on how important. I got Len Cariou out of one we were talking about Len before because someone else here met it. Len Cariou was a performer in Applause, and he had the lead in Little Night Music. And he was in a contract, and he wanted to get out of the contract so he could go into a Little Night, I think it was into a Little Night Music, or into one of his other shows. I got him out of the contract. It's that kind of thing. Another client, let's see, most of it is really negotiating how big the name is, or how much they're paid, or when they can get out of the contract, that kind of thing. Yes?
Would you recommend these things make sense for a successful performing artist or writer? I guess I'm asking you how much people like you cost for the starting artists, whether or not we should invest in.
Well, how much do lawyers charge?
For someone who's not established and who's basically going to be poor for a while.
Well, let me tell you, I represent a lot of people in this business, and I charge them all differently. Part of the way I charge is based on what they can afford to pay. The price for an off-Broadway show is about, less than a third of what it is for a Broadway show, and you do more work on an off-Broadway show. When you represent a not-for-profit corporation, you have to charge less than one that's very, very successful. You fix the fee based on what the party can afford and what work is involved. If you're representing a well-known performer who's a star, you can charge more because the work is more and they can afford more. Someone who doesn't have any money, you charge a lot less. How much less? It can be as little as nothing. I try not to charge nothing, even if I tell them they owe me a bottle of J&B, because people don't appreciate something if they get it for nothing.
I know you recommend the lawyers, but again, for the starting artists, concerning contracts, what are the basic type of loopholes, things like that we should look for, things that would like to get us in over our heads, that kind of thing?
Well, unfortunately, the kind of things that you find in contracts are very difficult to alert you to. You'd be astonished if, in the first place, most people who sign an agency contract, for an example, or a management contract, don't bother to read it. And if they read it, they would have difficulty because they're usually worded in such a fashion. I wish I had one of the contracts with me, but some of the contracts that are used by some of the agents, you just wouldn't believe what they take. Now, all I can suggest is that loopholes, whatever you're signing, read it carefully, and if it's clear that it means something that you understand, and you're willing to go along with what it says, you sign it. If you don't understand it or don't want to go along with it, don't sign it. I'd suggest seeing someone who does understand it, and it's very usual that an attorney who deals with this kind of language all the time is going to be the kind of person who's in a position who can do it. Yes, there's a question over here. The gentleman behind first.
Could you go into some of the legal aspects that performing, say, you deal with the, say, a concert performer or an opera performer, and what sorts of legal problems this type of person is liable to run into?
I do very little work for that kind of performer. I've done a little bit for Judy Raskin, who's an opera performer, but she's never had any problems that were really great. They're just routine contracts. As far as musical performers, are you talking about rock groups?
No, I'm talking about
Because I do work with groups. You're talking about
Judy Raskin singing in concert.
yeah.
Let's say the full scene.
Well, I don't have too much to do with that kind of thing. I've seen some of the contracts. There have not been great problems with the ones that I've dealt with. There was a question here.
Well, this is sort of along that same line, but to be specific. At
Yes.
Iowa State this weekend, the
Mhm.
Boston Pops are there with Chet Atkins last night and supposedly Peggy Lee tonight. But a week ago, it was announced that due to her indisposition, she is not appearing, and lots of tickets were sold for Saturday night under the auspices of the fact that she was going to be there along with them. What is there, most of what you have said has been from the performer's protection, but what is there about the person who actually signs the contract in good faith that performer is going to be there, and then a week before the actual performance, poops out?
It's a very rough problem. You can't get an injunction to force someone to work. It's tough. It's particularly tough with one shot like this. If I'm commenting about a contract I haven't seen. Now, if the contract does not give her some out, I would be surprised. Most an out would be a physical illness. Now, if someone's physically ill, about the most you can do is get competent medical advice and get her examined to make certain that she's really as sick as she says. That's the kind of thing that is in the contract that would let her out. No, I wouldn't sign a contract which would permit her to get out for another engagement of any kind on television. Very often persons can get out of a show after a certain period of time if they have a television or a film commitment. That's something else. We're talking about a one-night stand. I should think, without having seen your contract, the contract should be pretty tight to bind her. I know of one instance where a number of years ago, Tammy Grimes went on tour with not the Music Man, the other one, the Unsinkable Molly Brown. She went, and Tammy Grimes had a history of not being well whenever she felt like not going on stage, and she was sick quite a bit. Sick, in quotation marks. She got to Denver, and she was sick. Her understudy was a gal by the name of Karen Morrow, and Karen I knew from, Karen's first appearance in New York was in a play called Sing Muse, which was written by Eric Siegel. Eric Siegel, who wrote Love Story. And believe me, someone mentioned this morning that Actors Equity used to give shoes to their members. Karen Morrow went and got a pair of shoes before that show because she couldn't afford a pair of shoes. She was so poor. So Tammy didn't go on, and Karen went on, and they were reviewed that night in Detroit, or in Denver, and Karen got a wild rave. Tammy was never sick again on that tour. Not once. So just carry around a Karen Morrow with you, or someone who can. It's a tough problem, and I think about the only thing you can do is to write your contracts as tightly as you can, so that the only out they have is what is really a legitimate out. And also, you can also make provision that if there is an illness, they have to furnish you with someone else to replace them. The mere fact that you've got the money doesn't help you any. You've got to have someone on that stage. And the person who represents the booking agents should be made responsible to replace whomever can't make it for whatever reason.
Well, she was replaced. It's just that a lot of people, I think, bought tickets
Right.
in order to see that particular hope wasn't announced until a week later.
Yeah. Was she sick?
It just said due to the imposition. It didn't say illness or anything like that, which
Yeah.
made it all the more heavy.
I can speculate with you, but I don't know what happened in that instance. But
It was probably a management who did it. Or I mean,
yeah, I believe it.
negotiated.
Yeah, that didn't surprise me either. There was another question here. Yes.
I was just asking, like, in past years on television, there's been quite a few presentations of stage productions. Now, when, like, if Vonnegut would sell the, say, stage rights to something, does that, when rights like that are sold, does that also mean that any presentation of that stage production may be shown in any form?
No, you see, this is what we have. This is really what you have to be very, very careful about, and what I do. When you sell the stage rights to something, it's